Just one moment. Okay.
Good afternoon. We have had a prolonged off-the-record discussion regarding motions that are presently pending before the siting board from Eversource with regard to a supplemental notice for a route alternative that it is proposing, and with regard to a motion filed by MIT for supplemental notice relative to 3 route variations that MIT is proposing. I'm going to briefly ask that the parties summarize the statements that they made in support of their motion or in opposition of each other's motions during that procedural conference.
Presiding Officer Sharkey, should I start with the company's motion?
Please. Thank you, Mr. Rosenzweig.
Thank you for the opportunity to speak today, and I appreciate everyone's participation in what was a pretty detailed discussion off the record regarding these 2 motions. First, with respect to the company's motion, we have asked for a limited re-noticing of a portion of Route S15. S15 is a route that goes from Cambridge into Somerville from the new substation to Station 402. It has been the subject of essentially 2 prior public comment hearings and substantial evidence in terms of discovery responses so far in the proceeding. As the company has continued to refine that route, it identified a couple of small shifts in the location of that S15 route that, as I said, has been previously noticed, and is seeking an order from the siting board allowing it to conduct limited notice of that S15 route as it relates to the revisions that it is now proposing. And the notice would not involve a public comment hearing. We don't think that's necessary given prior public comment hearings. It would involve direct notice mailings to 11 affected properties. And I say 11 affected properties. There are only 11 properties that are either direct abutters, there are 5 to the revised S15 alignment, and 6 new abutters, that is to say, within 300 feet of that revised alignment. However, all of those 11 abutters, as well as hundreds and maybe even thousands of others, have already received notice of the company's routes in the Somerville study area, including Route S15. So we believe our request is consistent with siting board precedent, would allow for completion of the sort of procedural aspects of bringing that route into the record of the siting board proceeding and allowing that evidence to be considered and the S15 route to be evaluated as the company's primary route for that portion of its petition. So we ask the siting board to grant the company's motion and to allow it to go forward with the limited noticing that it has proposed, which would include direct noticing upon the siting board's ruling of a notice that we have drafted indicating the revisions to the route S15 to these 11 new property owners, giving those new property owners essentially 2 weeks upon receipt of the notice to file written comments if they wish, or some sort of formal petition for participation in the proceeding. And depending on the scope of any written comments or requests, if they are forthcoming for formal participation, the siting board would assess whether additional procedures are required at the siting board. So that's our motion. We would ask that the siting board grant it.
Do either of the other parties have any objection to the company's motion? I note that we have received none to date.
MIT has no objection, as they stated in our pleading.
Thank you, Mr. Dutori. Mr. Olson?
Cambridge has no objection.
Thank you. In that case, could we turn to MIT's motion for a supplemental notice?
Thank you, Presiding Officer Shockey. MIT has proposed several route variations in this proceeding. Our hope is that the decision on those will be made on the merits based on whether they're clearly superior to Eversource's options on the basis of cost, reliability, and environmental impact. During the course of the proceeding, issue has been raised by Eversource that the need to renotice the MIT's variations would cause delay to what is a project that we concede is needed. From MIT's perspective, Eversource's request to renotice a route variation of their own provides a good opportunity to do the same for the MIT variation, so that essentially that issue is taken off the table. I would say, I don't know if the appropriate time to say that there has been some discussion about an alternative way of handling this. That's something that I can address now or later, but it'd be an alternative that MIT would be amenable to.
If you could expand on that then?
Sure.
Now?
So we did have a very productive and extensive conversation off the record. One proposal that came up was from staff, was the idea that the board would proceed now with granting Eversource's motion and having that notice go forward, and we have no objection to that. That a ruling would be deferred on MIT's motion pending completion of the evidentiary proceedings and submission of the briefs, and that at that time, some point, hopefully promptly after that, the citing board would issue a ruling on MIT's motion. And that we think is a very reasonable compromise that we would support. Thank you.
Thank you, Mr. Dutore. Mr. Rosenzweig?
Thank you, Presiding Officer Sharkey. I will try to be brief. The company's position on the MIT motion is that it should be denied. It's based on what we think is a fundamentally incorrect premise that the circumstances surrounding the MIT proposed routes are the same as the company's proposed renoticing of Route S15. We think the two are distinctly different. I can go into that in some detail, but I would rather just highlight a few issues for the staff's consideration, and then I will address the alternative proposal that Mr. Dutore discussed, that was discussed off the record and put forth by staff. So the issues we see with the renoticing of route, the MIT routes, are not just a matter of conducting the renoticing. It's that this project is so time sensitive. It's an acute need, I think, that is broadly recognized by the parties, and any delay in the process to get this project approved and the citing board to issue a final decision is extremely problematic, not just to the company, but to the residents of the city of Cambridge and the city of Somerville. And we really feel very strongly that that has to be a paramount consideration to the citing board. We think the circumstances surrounding Route S15 and the MIT routes are very different. The S15 routes have been on the table since the outset of the company's petition. They've been subject to 2 public comment hearings so far. The MIT routes are new and come very late in the game. They involve completely different routes that have been not subject to notice. There are opportunities along the way for MIT to propose these routes that it did not take advantage of, either through the pre-filing engagement process or earlier in the procedural process with the citing board. We believe that a determination by the citing board that would grant the MIT motion at this point would be a very adverse ruling that has significant downsides and would have prejudicial effects for this and future proceedings. It would allow proposed interveners or actual interveners that may oppose a project to suggest at any point in time, despite previous opportunities, new routes, entirely new routes, and suggest that they be noticed. That type of noticing procedure where the company would have to investigate those routes at full length, conduct outreach, conduct engagement, study them, engineer them, and put them in a position so that they were that the company was comfortable subjecting them to public notice and inclusion in its petition would be a very protracted process, as we've estimated would be a year or more. And we can't afford that type of delay. And that would be a type of delay that would be adverse to all applicants going forward. And frankly, the siting board's process, which has as one of its elements, conducting its reviews in a very time efficient manner, hopefully within 12 months, but if not in 12 months, as soon as practicable thereafter. And we are all aware of SJC precedent that supports those statutory requirements. So we do not support the MIT motion, and we think it would be a very adverse and unjustified process to follow in this proceeding. I would comment on the proposed alternative that was advanced by staff. We think that is an appropriate compromise. We're very late in the hearing process. Hopefully there's only a few more hearing days to go. All the evidence will be in on the merits of the company's proposed routes, as well as MIT's proposed routes. Soon thereafter, there will be briefs that will be filed by the parties that they can advocate for their proposed routes as they see fit. And the siting board staff would be in a position to evaluate if there's any reason, any compelling reason why the MIT route should be subject or granted an additional process and opportunity to be formally included as a potential set of routes that the siting board might approve or consider in a formal way in the final decision. So we would only ask that the siting board staff issue such a ruling as quickly as possible to maintain schedule to the extent it can, so that this project has the best opportunity of being approved and reviewed by the siting board in a time frame that will allow the company to meet the time-sensitive need that it is identified in the record. Thank you.
Mr. Olson, would you like to say anything with regard to this motion? You're on mute, Mr. Olson.
Nothing in addition to what the company just expressed, and also to say that Cambridge supports the compromise approach that the board has brought forward. Thank you.
Thank you, Mr. Olson.
Have you heard briefly?
Yes, please, Mr. Duttori.
Sorry. Given that there's a consensus on the compromise, I'm not going to respond to the company's arguments, but I don't want that to be taken in any way as agreement with them. Thank you.
Thank you. Well, we will not issue a ruling on either motion at this time. However, we will take it under advisement and expect to issue a ruling in the future. In light of what we heard today during the procedural conference and on the record in since we've resumed the hearing today, we will begin on Monday with the direct testimony of MIT's witnesses. I would prefer, in terms of order, after we have addressed the MIT testimony, for any questions related to the City of Cambridge's pre-file testimony, which we received last night, to be examined on the record, and then follow with the Somerville pre-file testimony. However, I note that Mr. Shapiro is on vacation this week and is not available. So if there are any constraints related to addressing Somerville's witness availability. I expect I'll hear about them first thing on Monday.
Presiding Officer Sharkey, we don't need to do this on the record. I just have a scheduling issue on Monday that for Ms. Watkins that I wanted to just briefly bring out. We could do it on the record if we.
Please let me know now. That's fine.
Sure. Well, she's just she won't be available probably until after 1 o'clock, 1:30, something like that. I don't know how that will work with the timing of MIT's witnesses, but that's a constraint that she has.
Well, my expectation is that the questioning of MIT's witnesses by the bench and by company's counsel would probably not cause that to be problematic on Monday in terms of Miss Watkins' availability.
Okay, great, thank you. Oh, and she also, I think she needs a link to the to be a panelist. I'm not sure she has that, so.
I'm sure she hasn't. They're individualized, so if you can send me an email with her email address,
Sure.
we can send her a link that she can use on Monday and thereafter, because it's the same link she would continue to use throughout the hearings.
Okay, great, thank you.
Is there anything else we need to address on the record?
Ms. Sharkey, just so I understand the company's motion, while there was no opposition, we should await a ruling from staff in writing before we go forward with notice to those 11 new abutters. Is that the way we should consider this, the status at this point?
Yes, that's correct. Thank you, Mr. Rosenzweig.
Thank you.
If there is nothing else, we will adjourn for today. I'll expect to see all of you in probably a larger group on Monday morning at 10 when we resume with our hearings.
Thank you.
I'd like to thank everybody for
Thank you.
participating today. Off the record.